quality handmade soaps, where handmade is the best made. Proudly making soap for over 5 years, Quality Handmade Soap sets the standard in both quality and safe ingredients. Perfect for the holiday season. I'm telling you right now, you see that Black Rose soap, I got that in my shower, and man, let me tell you what, your husband or wife will love it. Use promo code VHHN2022 to get 15% off your first purchase. Link is in the description box. Let's go.
Williams, practicing 16 years in Chi-Town. Peace, brother.
Yes, sir. Peace. How's it going?
Hey, how you doing, man? Thank you for coming on this evening. Won't you introduce yourself to the people, man? Let them know who you are, what you do, and what you specialize in.
Absolutely. I appreciate you. My name is Anthony Williams. I'm an attorney. I've been practicing actually in my field for over approximately 17 years. I graduated from Tuskegee University, all HBCUs, went to Texas Southern University, Thurgood Marshall School of Law as well. I wanted to volunteer myself to, you guys' platform, just to, share whatever light I can on, any type of legal questions that you have. So I'm here.
Let's jump into first, because we talked about this earlier, and I'm not going to hit you a new curveball, I promise. You know what I'm saying? The Alford plea.
That's fine. You can hit me with it. I'm ready for him.
All right, cool.
Nice.
Let's talk about the Alford plea. And I read the statement from Gunna's attorney, Steve Saddle, where he pretty much said that he was taking this plea, and this plea would not be able to be used at any point in his trial or against any other current witnesses. Could you kind of just elaborate on the Alford plea and that as well?
Right. Yeah. So from I think the first thing to kind of it's almost like you have to do with your analysis, you got to do like a bifurcation, right? You got to kind of separate when we talking about a plea versus when we talking about somebody making an admission, right? You can always get a guilty plea without somebody making admissions to the facts, right? So according to the Alford plea, based on our conversation earlier and me kind of doing a light research specifically of that term, since that's the term that was coined, my understanding of that is essentially that is the person that is pleading, making the plea. That person specifically is saying, although I might not be guilty, the state or the prosecutor, whoever they is, they have enough facts to convict me. Therefore, I'll plead. Right. That's saying one thing as it relates to themselves, but the fact of whether you attest to or whether you are agreeing to certain facts, that's something different. For example, a person can, plead guilty all day long to a shooting, to a DUI, to whatever the case may be. But when you open yourself up to be sworn in, you raise your hand, you get sworn in, and you say, I swear that, oh God, did A, B, C, and D. At that point, at the point when you're swearing yourself in, the only purpose of that is for the prosecutor or the state's attorney to tie you into those facts.
Wow.
And usually what happens is when they tie a person into those facts, the purpose of that is to kind of catch the other co-defendant. So essentially what will happen is you, at a previous date, let's just say in that particular case we're talking about now, it's not in a trial posture. Let's just say it goes into a trial posture in 2023, right? So at the point when it goes to trial, they can come back and get the person that got sworn into the facts and say, isn't it true that in December of 2022, on what was yesterday's date, the 15th, you swore that A, you also swore that B, you also swore that C, so that's pretty much how the state or the prosecutor used that tool. Now, that's not to say that at that point, whomever it is that swore to the facts can't, recant and say, oh, I was just lying just to, do whatever. But, and then that'll be an issue for the trier of fact, whether the judge or the jury would believe that you lied in order to get released, get a deal, or get whatever you got. You know what I mean? In order to get out. But I think the real issue is a plea is different than being sworn to the facts. And at the point where, and I have had defendants all the time that have pled guilty, but not necessarily sworn to the facts. And when a person does plead guilty and they ask to get sworn to the facts, I have the longer conversation, where you having this longer conversation like, hey, you know what this means, right? You know they're gonna mess around and call you back, and you're gonna have to testify against your buddy. Right.
I want to read something. This came out a few hours ago. This is out of Rolling Stone. The headline is "No Gunna will not testify against YSL," and it reads, "Gunna will not be called to testify against any defendants in the indictment against Atlanta-based YSL. Gunna was released from Fulton County Jail Wednesday on the Alford plea agreement and was sentenced to 5 years. We just spoke about that. They also say it is understood that the state is not going to call him as a witness. The source, who wished to remain anonymous due to the ongoing nature of this YSL case, explains that's why the plea agreement is written exactly the way it is, because the whole idea was the state wasn't going to call him, and they didn't want the defense to call him either. If you look at what was said in court, that stops the defense from calling him, but also indicates that he's never going to testify for the state. The source contends that the aim of the plea is to neutralize him and keep him out of the game. How are we to interpret that?
And that comes with, I think at that point you have the nature of the agreement, right? We will probably never be privy to the nature of the agreement between the parties, right? So we won't necessarily per se have the actual content of what was agreed to between the parties. But what we do know, and based on my experience, what we do know is we have, an accused, a defendant, who accepted a plea where he admitted culpability, not only for himself, but for a co-defendant. And I believe he admitted at some point where he didn't have ownership of certain contents that was in the vehicle, versus, whether or not the other person did. So, I can't per se, of course, talk to the contents of, what was actually in the plea agreement. But I would say this, under the theory or the old antics, where there's smoke, there's fire, or if it looks like a duck and it quack like a duck, then what is it?
It's a duck.
Right? Well, based on my experience with prosecutors and the reasoning for them requiring a person to make certain admissions on the record and get sworn to the facts, you can say they could use it to tie a person in. Number one, to tie the person in to that version, right? So now, if they try to deviate, if they're called later on as a witness, if they try to deviate, you can say, okay, well, look, this day you swore to tell the truth. You did tell the truth. You're being honest, and this is what you said. So not only do you have that, but you have you're tying them to the record just in case you decide to call them. So I could see where, a person would say to neutralize, them at a later date. So now he can't say whatever was not a gang, or, you weren't in the car on these particular days. I can see where you can say you can try to neutralize them to that point. But based on history and my experience, I would believe that they tied them into the facts specifically to, tie his testimony in case they called him on a later date, so that he can't deviate from those facts and that they could use him against his co-defendant.
Gotcha.
Right. And one part.
See, but that's the hard thing about it, is one of those things where we kind of just gotta wait for the other shoe to drop, right? Mm-hmm. And we gotta wait for the trial in order to see, because let's just say under some circumstances, like even though he swore to the facts that he swore to, and although he swore to some facts which you and I may perceive to be damning, right? We like, I can't believe he did Young Thug like that. We may look at it like that, but it really wasn't like per se crucial. You know what I mean? Like, he didn't say that whatever was in the car belonged to him. He didn't say the gun belonged to him. He didn't per se say, you know what I mean? So it's still wiggle room there for, the attorney to potentially, say that, just because it was, Gunna or whatever denied it does not mean that it's per se my clients, so it's still room for him to, for the defense, I think, to work at that point.
Right. Well, I think one part that we left out also, somebody dropped it in the chat as well. He did admit to seeing criminality from them as well. How does that shake things up?
Right. See, and again, you're gonna have to, everything, most criminal offenses, right, have like what they call like a mens rea attached to it, right? And when they say mens rea, they mean like, that mind state. You knowingly did A, B, C, D, E, F, G, whatever it is. Like, you had that proper mind state to commit the offense. So even though this one person that swore to the facts, he admitted to, or he, swore to certain things, that to me, that still doesn't prove the mens rea, the mind state of, the principal person, Thugger, in this particular case, right? It still don't prove that Thugger knew what was going on. Like, you have to be able to prove that. So, oftentimes, without saying too much, oftentimes we are, as, being with defense counsel, we kind of are lucky that, the prosecutor maybe stopped short a question or two. You kind of look like, thank God he didn't ask, that other thing, that where he could have tied it in a neat bow. You know what I mean? He kind of stopped a question or two, before where he should have did that would have really like damned our, client off, So I think that although there was a certain admission, the defense probably still will have some room to work.
I want to ask you, what do you think overall about Young Thug's current situation? But before I do, how does Gunna's statements or the question or the answers to the questions that were asked to him before his release, how does that affect Young Thug's current situation?
You know what, though? I think it never can be good, right? I don't think that it can be good regardless of what you look. A co-defendant statement can never be good for you as as the principal. It can never be good because, it makes it look like, it's the Titanic, the boat is going down and everybody is jumping off the ship to save themselves, and that's not a good look. Even if he comes back and try to digress, like I said, even if he comes back and say, well, I was just saying that just to take the deal that to your average person. When you think about this, you got to think about similar to your viewers, or similar to, like, it's, you get, I think the mind state of the juror, from the defendant's point of view, the mind state of the juror is underestimated. It's just your common everyday people that watch TV, that use the same inference to come from A to B to, jump past C and get to D. So you gotta respect the mind state of the juror, the inference, everything that they avail to. You gotta expect that they listen to, your platform. You got to expect that they listen to other platforms, that they're putting these things together. So, it's not enough when the co-defendant, I think, swears to a statement and then try to get back on the stand and say, yeah, you know what, I was just lying. I was just saying that just so I could take the deal. At that point, you talk about veracity of the witness, the believability of the witness. And when you talk about that, I believe that when it comes to trials, that if you burn your veracity, if you burn your ability to be perceived to tell the truth, at one point in time, people will always continue to question that, So as it relates to your question specifically with Gunna and how does that, how that affect Thugger's case, I think that it can't be perceived as good.
Yeah,
absolutely.
Yeah. Now, the other thing, like as it relates to his case and his Thugger's case, when you alluded to that, to be honest, it'll be like I would be less than to me a good attorney if I try to talk on that case without seeing any other facts. Oftentimes. If I, even with my cases, right, I'll get them in, my client will say, what do you think? And I'm like, I haven't received the discovery yet. Let me get the discovery. When I get the discovery, then I'll be able to let you know exactly what I think. Even if I only got like part of the discovery, let me get the rest of the discovery, and then I'll be able to tell you. So if somebody, who's not on that case starts to try to tell you about, perceptions and what they think and his chances and things like that, I think it's a stretch, because without being on that case, without having that file, without having the facts before you, it'll be a stretch and a long guess.
Respect.
Definitely. Now, you talked about the jurors earlier.
No doubt.
You done a lot of trials. You said you done jury trials and judge trials. Obviously, they don't want a jury trial. I mean, I'm smart enough to know that.
Right.
I want, I guess 11 or 12 people rather than one person judging you. What type of people if you could speak on this, is the defense trying to get? Is it going to be from the Atlanta area, Fulton County? What type of people do you think they get?
You know what? That's a great question. That's a great question. And and again, it depends on, and I believe that for the answer to that question changed the more I practiced law, right? Now, I would say the type of juror that I would want depends on my theory of the case that I ultimately would have, right? So if you have like a simple case with a simple theory, you would probably want, people that can just accept those facts, common people, or people that will understand your plight. If you had a more complex theory of the case where you need like kind of thinkers on there to understand the strategy, like let's just say, in Young Thug's position, right? He's like, okay, I'm so much of a boss that for me to be at the top of the pyramid, to understand what's going on at the bottom of the pyramid, that would take a lot. I have people that I tell what to do daily, and then based on when I tell them what to do, they kind of, follow order, and then based on that, they run off to task based on what I tell them to do. Right. In that particular case, you would probably want a different type of juror, maybe a manager, you are a manager of lots of people, and those type of people. So I think that the specific type of juror that you want, you're going to want somebody who is empathetic or can kind of vibe, for lack of a better word, with your theory of the case.
Right now, being as though
And
that's
every case has to have a theory. Like every case has to, you got to be able to summarize that theory in, 5 sentences. Thugger did not commit the offense of this because he did not knowingly, know that these people down here were doing these acts, at this time because he was too busy off in California, wherever else, running his business. Nor should he have known that these street people,
Right.
right. Would you like,
Yeah.
in your opinion, would you say like people like, say if you saw me and him, we were jurors, would you try to kind of get rid of us, knowing that we're like more from the hip hop genre? You're looking at people like that, what they're wearing, what
Oh,
lifestyle
you
they
know
come
what?
from. Yeah.
Hey, and they got it's called a Batson challenge, right? So let's make sure that's it. I believe that's what it is, where you can't, where you're not supposed to get rid of a juror because of race. So,
Okay.
with that, just to kind of speak on it, they can't. Yeah, they can't get rid of a juror because of, dismiss a juror because of their race. But, sometimes they find other reasons, right? So it's like, if a police officer sees somebody of color or a person other than white driving and they want to stop them, but they don't have a reason, but they'll say, okay, well, you have a picture of a cross or an angel on your hanging off your rearview mirror, right? So we're going to stop you for that, saying you were obstructing your vision, but really they just wanted to get to your license and get inside your car to see, if you have any drugs or anything like that on you. So, and that's been used. It's called like a precursor, but if the precursor is valid, then they can still do the stop. Well, the same thing. Oftentimes, I think that people would get rid of more empathetic jurors, and they believe that the let's just say in this particular case, like you alluded to, the hip hop type juror or somebody who look like they might listen to that. They might try another reason to get them off the jury. And I've seen, let's just say a person may have had a criminal charge from, that person may be 45. They may have had a driving on suspended license or a DUI when they was 18, and if they forgot about it, and they got a laundry list of questions that they ask you when you're applying to be a juror. Have you ever had any criminal background? Do you have pending cases? All these things. So you got to answer it. So, when you go to the jury, you put no right there and you get questioned and they say, well, you put no, but didn't you have a DUI back in 1979? Now they could get you off the jury because, you forgot that you had this, this case way back when, and you forgot to put it on the doc. So yeah, it's reasons why they try to, pick empathetic people off. And it's a strategy thing, right?
Right.
But yeah, definitely. I would, like I say, when I first practiced, I would always, try to go for the more familiar juror because they felt easier to talk to.
Got you. We a couple of years ago now, which is crazy to even think about. O and I went out to AR Ab's trial. We caught a few days of that. O more so than me. And while we were sitting there, we listened to the defense, we listened to the prosecution, and nowhere close to law experts. I didn't think being in the building that day, those few days, you had to be seeing the substantial amount of evidence the defense had in defense of AR Ab and the surprisingly like low amount of evidence that the prosecution had on him. It wasn't really sticking. And it also seemed as though the judge that afternoon was very partial to the prosecution and really, really biased toward the defense. And then we see the result and we see the verdict of him doing 40
So
something
let
years.
me ask you this. Well, I don't know. Was that a jury or was that a bench?
Jury.
It was a jury.
It was a jury trial? Okay.
Right.
Yeah.
So,
Yeah.
Yeah.
So what I want to ask is,
Go ahead. I'm sorry.
No, I'm sorry. What I want to ask is from
No,
your position, right? Because we've seen it clearly on one side, but it seemed like the fix was in when we were in there and we seen a result. As a lawyer, as a defense lawyer, if you're sitting in that situation, do you kind of know that, all right, the fix may be in and there may be nothing, no matter what we present, there may be nothing we can do because they want you and they're going to get you. Is it that deep in this?
well, that's why we, that's why we choose a jury, right? And it's supposed to quote unquote be a jury of your peers. But the likelihood that is a jury of your peers is, kind of slim to none because, our peers would be, more African American and, whatever. But and it's a couple of caveats that goes along with it. To answer your question, yes, sometimes it feels like that we are the only thing. When I say we, I mean the defense attorney is the only thing that's stopping this powerful locomotive train from coming down, on our clients, with our clients behind us, and we're kind of like, stop train, but here comes this train, right? Because it feels like not only, is it difficult, prosecution wise, but the judge is not ruling in your favor, just a lot of different things that's not going your way. But we still, we stand. And that's one of the reasons why we, when you get the jury trial, you let the jury know, my client chose you. He had the choice, and this is what I do. I tell him, my client had the choice. He could have went with a judge, but he wanted you, and at that point, the client got, I think we say at least three choices, bench or jury to plead guilty or not guilty and to testify or not, and yeah, so you let them know that you're here because my client wanted you to be here, and yeah, and if the facts are, in your favor, hopefully everything will turn out right. But it's still no guarantee. I've been in juries where, I had clients that were, they couldn't afford certain clothing, and so, behind the desk like this, you couldn't see down further than that. So when my client went up to testify, he had a suit on up top, but at the bottom he had on gym shoes. That's what we call them up here, gym shoes, sneakers. So, but anyway, when he walked across and, the jury saw that, ultimately he got found guilty. And when I went to ask the jurors after, like, what happened? Why did you find him guilty? One of the things was, one lady said, well, he thought he was sneaky. He had on gym shoes in that suit. And I'm like, what did that have anything to do with the testimony of the client? You know what I mean?
Crazy.
But yeah, but that's, jurors like find some of the quirkiest things to, but and that, again, that's when I was a younger attorney. Now I think I'm an optimist. So I believe in people. So I try to speak to people when I do a jury. So, we just kind of go from there.
Right. We won't hold too much longer. I want to ask you, I was just kind of like, this was kind of, ringing in my head to ask you, is there ever a time where a judge trial is better than a jury trial ever in any particular type of case? Or is it always better?
Okay. So, to me, and, of course, you got a ton of viewers and some of them may be lawyers, so they may think a little different. But to me, it's an old maxim, right? An old saying where they say, if your case is about the law, you choose a judge. If your case is about like facts, where you want like emotion to ring out and things like that, then you choose a jury. So that's like the initial determiner in application, what I use. Like, is this a legal case? Is this a legal issue? Let's just say when we talk about mens rea, right? That's a legal term. Mens rea means nothing but mind state, right? So a person knowingly makes physical contact with another, right? So,
Right.
but if my case was about where the person tripped and he fell and he bumped into him, well, you know what? He didn't knowingly do it. He didn't have the proper mind state. Explain that to the judge. But if it's more of a factual case, then you're supposed to go with the jury. But it's never really that simple, especially the higher the cases and the more that's at stake, right? So that being said, with the more that's at stake, I generally tend to lean towards jurors because I'm not comfortable with the fate of my client's hands being in one person.
Powerful. Definitely good. Yeah. So tell us a little bit about your practice on the way out. And make sure you give yourself a shout out as well, your website and what you could do for people as well. That'd be dope.
Yes, sir.
No doubt. Thank you. I appreciate it. What I'm venturing into now is personal injury and medical malpractice referrals. So you can find me on Facebook, Instagram at AFW Law. My website is www.afwlawgroup. And again, if you or your family members have been injured, y'all.
Yeah, man, it's slow over here, man, on the hip hop and sense of podcast and newsworthy shit. But
Right.
I think I had some. Oh, you know what? I seen this today. Oh, and I'll show you the picture of it. It's a picture of Akeem Woodbine and Dave Chappelle. Hold on, I'll show you real quick.
Oh, Bokeem.
Yeah, Bokeem.
Oh, okay. Right. Okay.
So in the caption it says, "Real shit. I think at this point, every single one of y'all that called me the evil Dave Chappelle owes me an apology. And if you still can't tell us apart, I'm the one that doesn't have Elon Musk Johnson in his mouth."
Bokeem said that.
This is what it appears to be. So I seen this morning. I started doing some back referencing, and I tried to find his Twitter. I tried to find his Instagram just to confirm this was true. Because if it's true, he's gonna talk about it, right? And you type in, it says Bokeem Woodbine and then at Bokeem the Dream. Wow. And you type that into Twitter.
Oh yeah.
You're gonna find some shit you don't want to see. It's damn sure not his Twitter page.
Oh wow.
There's some other. I don't suggest any real nigga do that shit.
What the hell?
So this is. But it's getting around. You see major. You seen Dr. Boyce posted today.
Oh, I didn't see that.
I seen hip hop platforms posted today. Wow. This kind of information starts getting out, and the narrative starts getting spun to where people think this is true. But if you really and I don't know if he feels this way or not. I don't know. But when I looked and referenced, tried to find this man's stuff, nowhere to be found. It was all fake shit.
So he had to say anything about it.
I don't think so.
Wow.
But now it's out there as if he did.
And I see with stuff like that, you never know. Unless it comes from like they're verified, and sometimes they say they got hacked and stuff like that. That's why I think sometimes people don't even care. You know what I mean? Sometimes they don't even care, whether they might just call Dave on the phone like, "Dog, that wasn't me."
Right.
They just hang up. Sometimes people do. They'll come out like that was some bullshit. Boom,
right.
Boom. But yeah, that shit is wild, man. I'm what's on that fucking Twitter though? Could you give us a hint? What's on the Twitter you looked at?
Dicks.
What?
I don't know who. I didn't stick around long enough to find the fuck out. I seen a dick and I dipped.
Bokeem, that's supposed to be his page, supposedly.
Yeah, so if you look on the John, right, it says Bokeem Woodbine and at Bokeem the Dream, like that's his handle. Like, so if you were to type that in, his Twitter profile should have came up.
Oh, okay.
Instead, Dicks came up.
Oh, somebody fucking.
So they playing.
Yeah.
You know what I'm saying? So I'm like, okay, that ain't his real John. So I tried to type it in and look it up.
Damn.
And I couldn't. It's nowhere to be found to make sure that he went and did this.
That's fucked up.
So like, if anybody go look, I don't suggest anybody. Just take it from me. All right, it ain't what you want to see.
You know what? Looking now,
little weirdo bull.
Yeah.
Like, shit. And then this post came up again, but I don't think this is real. And it got 73,000 retweets, 31,000 quote tweets, 325,000 likes. I don't know if those numbers are manufactured, but it's starting to get around.
I don't know. What's up with Bokeem?
I would love to get him on here. Yeah,
maybe he'll come talk soon. Somebody, I'm sure if it gets big enough, he'll probably say something.
He stays low profile, but
yeah, he do.
This is making its rounds. I won't be surprised if either one of y'all see it after we talk about this because it's making its rounds a little bit. And
so you said Bokeem said that Dave Chappelle got Elon Musk.
Yep, he said it. I'll read it again. He said, "Real shit. I think at this point, every single one of y'all that called me the evil Dave Chappelle owes me an apology.
Right.
And if you still can't tell us apart, I'm the one that doesn't have Elon Musk's dick in his mouth."
Damn. Woo!
And I guess that referencing from Elon Musk coming to Dave Chappelle's show and getting booed off stage and things like that. But I never heard of the evil Dave Chappelle. I mean, they do kind of
Me
resemble each other when you look
Right.
at the shit, but I never heard of that. And
Me either, because I'm like, Bokeem is like, what the fuck does he do? He
Right.
don't say nothing, do nothing.
he'd be chilling.
Right,
But when I read this, I'm like, oh shit, this is crazy. We got to talk about this. But then I tried to make sure it was real.
Yeah.
Couldn't find anything.
Damn.
But it's just a dangerous game that we play and we live in, that any kind of narrative can be steered. So be careful and make sure that you cross-reference and you get proper due diligence before you go ahead and, in particular, the media, because anybody can grab microphones now and call themselves media.
Yeah.
And these dickheads do.
Anything now.
And they'll post anything.
Yeah.
So if you want to be credible and have longevity in this shit, then I strongly suggest you stay away from stuff like this and make sure you do.
That's why a
your
lot
due
of guys
diligence.
don't show their face.
Mhm.
They know they ain't doing that bullshit.
Oh, you gonna get numbers. You put this something wild like this up and act like it's true, you get numbers, dog.
Right.
It's crazy though, man.
Man, I'm sure people probably got it up. Nobody got it up on YouTube.
I ain't looked
Talking
yet,
about
but you damn sure straight. I'm sure we can look at Bokeem and
Somebody probably got like 500,000 views of that shit already. Like, niggas, y'all niggas just...
probably know him too.
Right. And it's nothing you can really do to really regulate that. Like YouTube or anybody. There's just too many people, too many accounts.
Right.
You know? I know like Instagram, they have like a false information, like an information checker or something like that.
Right.
But it's like, I don't think you can ever really regulate that. It's like TikTok. So many people put so many shit up every day.
Mm-hmm.
It's kind of hard to really
regulate it.
Yeah, what's real and what's not.
Right.
You know? So, but that's wild though, man.
Yeah.
Unless you ain't see it or hear from the horse's mouth though. You know?
Gotta be careful.
Yeah, you gotta be careful. Definitely. Man.
That's some game for y'all, man, out here on this wet day, rainy day out here in New Jersey on the hip hop.